Good afternoon. Good morning to those of you dialed in from the West Coast. Welcome to our program today entitled Work and Family, What Nonprofit Employers Should Know About Family-Oriented Employment Laws. My name is Jeff Tenenbaum, Chair of the Nonprofit Organizations Practice here at the Venable Law Firm based in Washington, D.C. Thanks for joining us for our program today. You're definitely in store for a real treat today in what is a very complicated, to lawyers, very interesting area, really series of areas of the law. Some really interesting, difficult, complex issues that come up oftentimes on an almost daily basis at nonprofit organizations and, frankly, for-profits for that matter. And I'm glad that we were able to kind of package together, as you'll see, kind of a series of different federal employment-related laws and other laws that come into play when we're dealing with work and family issues in the nonprofit workplace. It's an area of law that creates a lot of confusion, a lot of questions, and hopefully our speakers will help to cut through some of that here for you today. Many of you know this is part of the monthly series that we do on nonprofit legal issues, going on close to 3 years now. Here in our Washington, D.C. office, we do these once a month, sometimes twice. You're always free to come join us for lunch if you're here in the D.C. area. We always have a webinar component, and we have about 150 people dialed in today from around the country participating in today's program. Let me give you a quick preview of our two upcoming scheduled programs. On January 15th, our program is entitled How to Safeguard Your Nonprofit Against Fraud and Embezzlement, Best Practices, Common Pitfalls, and Practical Strategies. We just sent out the announcement for this 2 days ago, and we already have 150 people that signed up for the program. I expect we're going to have a lot more than that. It's a very popular program. I've even heard from close to a dozen people who wanted to be on the program after we announced it. Clearly, it's a very hot topic, actually one of the hottest topics right now in the nonprofit legal world. And we have sorry, there's something wrong with the screen here. We have my colleague, Widge Devaney, who's a former federal prosecutor, is going to be leading our discussion. We have a director from the BDO firm who specializes in fraud and has done extensive work in the nonprofit area. And then we're very excited to have Joe Stevens, who is the key force behind the recent Washington Post investigative series. He's been writing a series of articles about fraud and embezzlement in the nonprofit sector, a series that's gotten a lot of attention on Capitol Hill and elsewhere, and he's going to be an exciting part of our panel for January. And then on February 19th, a topic that may be of interest to many of you since it's largely an employment-related topic, implementing a bring-your-own-device policy, what your nonprofit needs to know. Some really interesting issues that come up very frequently in this area. We have two of my colleagues, Ron Taylor and AJ Zatola, who are going to deliver a terrific presentation in February. We hope you can join us for that. A few logistics regarding today's program. We are going to take questions throughout the program. For those of you here in the room, Kelly there in the back of the room has a handheld microphone. If you need to ask a question, just raise your hand, and Kelly will come around so that everyone on the phone can hear the questions. For those of you on the webcast, feel free to pose your questions to me using the chat feature on the webcast software, and I'll pose those to our speakers at the appropriate times. In your handout materials, and those of you here in D.C. have in front of you a printed handout book that has a copy of all the PowerPoint slides as well as full bios of our speakers. Those of you on the telephone and the webcast should have received an email with the slides linked to them. And tomorrow, everyone who registered will get an email that contains the slides and a link to the recording of today's program. Feel free to share that with colleagues or others who may benefit from that. Our two speakers today, as I said, you can read their full bios in your handout materials. To my immediate right, Megan Mann, formerly resident in our New York office, now thankfully for me and for us, resident here in our D.C. office. And to her right, Nick Ryder, who came down from our New York office today. Megan and Nick are both lawyers in our labor and employment practice, both of whom do extensive work with our nonprofit clients and, of course, do a lot of work in the areas and the issues that we're going to be talking about here today. They're both terrific. They really know their stuff. They're very practical and are going to be, I have no doubt, be able to give you a very informative and, with Megan and Nick, a very entertaining presentation as well, I'm sure. So without any further ado, I'm going to turn it over to Megan to get us started. Megan?
Thank you very much, Jeff, and thank you all for joining us today. Please don't hesitate to let me know if you can't hear either myself or Nick, and we'll be sure to speak up and get you all of this glorious information that you need. So what I just want to start off by doing today is just a brief overview of the topics before I pass it off to my colleague Nick to dive in more substantively to the FMLA. The point of what we're doing today is we are looking at and talking about your employees as not just employees, but as family members with family member responsibilities. Your employees are women who are or may become pregnant. Your employees are both men and women with children or contemplating having children. They have elderly parents that require care. They are related to service members who are called to active duty. All of these reasons, all of these things that are going on in their lives outside of work affect you as employers inside of the workspace. And there are some pretty important federal laws and state and local that touch on these issues. And what Nick and I are going to go through today are some of the more major and relevant federal laws. And before I talk about this list, I do have to say, though, I can't emphasize enough, Nick and I are going to say it throughout the presentation, even though we're focusing on federal law today, it is extremely, extremely important that when you come across any of these issues, you always check with your relevant state and local laws, which are oftentimes more expansive and provide additional protections to employees than the federal laws. So Nick is first going to talk about FMLA, the Family and Medical Leave Act, and eligibility, what that means for you as an employer and your employees. As part of that, he's going to talk about taking leave for the care of a family member, like we said, a child or a parent. He's going to pass it back to me to talk about pregnancy. I'll go ahead and give you the disclaimer that what I tell you today might be different tomorrow. It is a rapidly evolving area of law. And I'm also going to go into break time for nursing mothers, some lactation issues you should be aware of. Pass it back to Nick for some common family caregiver legal claims. What's happening in the legal landscape, what's going on with the case law. And then I'll wrap it up with some just very basic practical employment policy tips. And like Jeff said, throughout the lunch period, throughout the presentation, we will be taking your questions. So without further ado, Nick Ryder and FMLA.
Thanks, Megan. Good afternoon, everyone. So as we get started, we're going to try to begin very broadly and discuss some of the eligibility requirements under the Family Medical Leave Act, also some definitions of qualifying reasons that an employee could take leave under the FMLA. And then as we get further into the presentation, we're going to get a little more granular and dive into some discrete issues that arise under the FMLA and related statutes. So the first question for any employer when an FMLA question arises, when an employee comes and presents a potential situation where they might need leave, is the employer a covered employer? Does the FMLA apply to that employer? And a covered employer under the statute will be a private sector employer with at least 50 employees that have been employed for 20 or more work weeks in either the current or the immediately preceding calendar year. It also includes all public sector employers. It includes all public or private schools. And even if you're not a covered employer, you still have to ask whether your employees are eligible. Even if you are a covered employer, you still have to ask whether your employees are going to be eligible. And eligible employees will include employees that are employed for at least 12 months. They have to have worked for the employer for at least 1,250 hours during the prior 12-month period. And they have to work at a work site of which the employer employs at least 50 people within 75 miles. Okay. So if you're a covered employer and if your employee is eligible for FMLA leave, the next question is how much leave do they have in their FMLA leave bank? And under the statute, employees have up to 12 weeks of unpaid leave in a 12-month period for any of the following qualifying reasons. There's the birth of a new child or to care for a newborn child. There's the adoption or the placement in foster care of a child. or to care for that child. There's to care for a spouse, a child, or a parent with a serious health condition. We're going to talk a little bit more later about what the definition of a serious health condition is. There's the employee's own serious health condition, which prevents the employee from performing his or her job. And there's and I have it in quotes here because it can be a little difficult to determine sometimes, but there's the qualifying exigency due to an employer's spouse, child, or parent having been called to active military duty. Now, in addition to those 12 weeks of leave that will be available for any of those reasons, there's what I call an enhanced leave component to the FMLA, and it's a bit of a recent development for military caregivers. An eligible employee can take up to 26 weeks of leave during a 12-month period to care for a covered military service member who has a serious injury or illness. And that serious injury or illness, generally, it has to either arise because of the military service member's active duty, something that happened in the line of duty, or it can be a previous condition that became aggravated during the service member's active duty. And the employee, it's the same spouse, child, or parent requirement, but in addition to that, it also includes the next of kin. So we want to dive into now the qualified reasons for leave under the FMLA, the things that we just reviewed. That's when a new child arrives, when there's a serious health condition, when there's a qualifying exigency because of a call to active duty, or because of military caregiver leave. It's important to note that it's not just the newborn child for when leave will be available. There's no distinction between a new child being born, between adoption of a child, or foster care placement of a child with the employee. And for foster care placements or adoptions, it'll include any child that's under the age of 18, but it'll also include, for example, if an employee adopted a 20-year-old who isn't capable of caring for him or herself because of a mental or physical disability. And one thing that's not up on the slide, but it's not as if the employee can take leave for a newborn child when that child's 3 years old. At some point, that leave is no longer available, and that's within 12 months of the birth of that child. So the next reason we want to discuss for when leave may be available under the FMLA is the serious health condition. And that's an illness, an injury, some type of physical or mental condition, and it has to either involve inpatient care or the continuing treatment by a healthcare provider. Inpatient care is pretty easy to determine. It's generally hospitalization. But the continuing treatment by a healthcare provider, that's where the employer and the employee might disagree sometimes. It doesn't include things like when an employee gets a cold, when they have to go see the ear, nose, and throat doctor for a day, when they're getting maybe a root canal or other dental work. What the types of things it includes are, say, prenatal care during pregnancy. It might be, for example, blood work after the employee had a serious surgical procedure, and every month they have to go see their physician and have blood tests done, and they need leave because they have to do that during regular work hours. It doesn't include things like cosmetic treatments, plastic surgery. The only caveat to those types of things that are excluded is when a complication arises. If someone does go in for a cosmetic treatment, say they have a mole removed, which wouldn't be generally covered under the FMLA, but then unfortunately something happens during that procedure where they have to be either hospitalized or start to see a healthcare provider on a continuous basis, then they would move from ineligible to eligible for FMLA leave. The next reason we discussed where an employee might be eligible for FMLA leave is the qualifying exigency for a covered military service member. And a covered military service member will be a member of the armed forces, including the reserves, and it's someone who has to be on active duty or at least notified of an impending call to active duty. They also have to be deployed in a foreign country in connection with the call to active duty, and it has to be the spouse, the child, or the parent of the employee, just like with the other forms of eligible leave.
Nick, before you go on, we have a question from the webinar that's relevant here. is the 26 weeks of leave for care of a covered military service member in addition to the 12 weeks already provided under the FMLA, or is it 26 weeks total?
And, thanks, Jeff. Fortunately, Megan and I were just discussing this before the presentation started, and it's not in addition to that. So it's just the 26 weeks of leave, not in addition to the 12 weeks.
Okay. One other question. May an employee taking FMLA leave also work from home on a limited basis and not lose their FMLA benefits?
We're going to discuss...
and I was going to say, for any questions that we're going to be getting into more detail later, we can definitely punt on those and cover them later.
Yeah, we are going to discuss reduced schedule and intermittent leave options, when they have to be offered, when they're available to employees. But the telecommuting issue does raise some issues for employer, but we'll get to that later.
Okay.
So the next thing we want to discuss are the definition of a qualifying exigency. And you can see there's, on the slide here, there's a long list of potential qualifying exigencies. I really want to highlight just two of them. The first one there, issues due to 7 or less days notice of deployment. That's when a covered military service member suddenly gets the call to active duty. It's not when they know far in advance, well, I'm going to be deployed overseas soon. We can make plans well in advance of that deployment. This is when, for reasons that arise sometimes, the covered military service member is going to be deployed suddenly in the next 5 days or 6 days, 7 days maybe. And the spouse, child, or parent of that military service member suddenly needs to do things. They might need to arrange for alternative care of their child. They might need to go to the bank during work hours and make financial arrangements because their spouse is going to be away all of a sudden. The other qualified exigency on this list I wanted to point out is the rest and recuperation during deployment. Sometimes active military service members, quite reasonably, are given R&R. They're allowed to return home during their period of active duty. And when that happens, the spouse, child, or parent of the covered military service member is allowed to take FMLA leave just to spend time with the military service member.
Nick, if I may just jump in for a second just to add on to something that you were both discussing. With the 26 weeks for a service member, Nick is going to be talking about the calendar, how you determine when your 12 weeks can be taken. Is that correct?
Correct.
So something just to point out and keep in mind, if you're working on the calendar year, you can take 12 weeks within the calendar year. You could have a situation where somebody's out for a serious health condition, and then it's December 31st, and they need to be out on January 1st for another serious health condition or service member care. And because of the way you calculate your calendar, you could end up having an aggregate of more than these set weeks. Is that fair?
Absolutely, and we're going to discuss it later, but the employer has some options for determining the 12-month period for most types of leave, but for military caregiver leave, there's a mandatory option for the 12-month period that we'll discuss later in the presentation.
Yep. A question here from the webinar that's very much relevant to that. It's kind of a two-part question. Can you give an example of 26 weeks military leave used in a year when the employee also has personal medical leave? If, for example, the employee took 12 weeks for military leave in the first quarter of the year and then in July had her own serious health condition, could she still have 12 weeks left for her own condition? Does that make sense?
Yes. I understand the question. The military caregiver leave is the bank. They're asking if it's going to be depleted because of the 12 weeks of military caregiver leave.
Well, I mean, it's a timing issue, I guess. If the serious health condition arises kind of mid-year, and I'm unclear exactly if the question is, does that then trigger some additional 12 weeks of leave for her own condition, or is this all kind of combined and aggregated? Yeah, I mean, that's if the questioner wants to clarify the question, that's all we have.
Okay.
But if you, I mean, generally, you know the issues that we're getting at here. Is there any other further elaboration that you think would be helpful?
I mean, one thing we'll just say is that if you have a serious health condition versus your spouse having a serious health condition, that is all part of the same 12 weeks. Where you get into additional would be with regard to the covered service member leave.
Correct.
And additionally, if you have to take off 6 weeks for a serious health condition, you still then have your 6 weeks for care of a new child. So in those ways it can be combined.
Yeah, the questioner just said that Nick summarized it correctly. Can the military leave end up depleting the medical leave if you go through 12 weeks of military leave before the health condition arises?
No, it wouldn't.
It would not?
Correct.
Okay.
Yeah. Many of the guardsmen and reservists are called...
Wait, Bert, can you just grab the microphone?
Many reservists and guardsmen are called to active duty to replace cadre who have gone overseas. For example, we have the Marine base at Quantico, and a lot of the trainers there were called up from the Marine reserves from all over the country. They didn't go overseas. So the military exigency wouldn't apply to a situation where they're called up, maybe sometimes within 5 days, to report to a domestic base because everybody else at the domestic base is in Afghanistan and they're training new enlistees or something like that. So they're not going to go overseas.
The call to active duty, per the federal regulations, must require deployment in a foreign country. So it's not necessarily when and this might depend on what you're meaning when you say, quote-unquote, called up. If they're called up for training and it's not related to a future deployment, a pending deployment in a foreign country, then no, they would not qualify. But if they're called up and they're training, and then directly after that training, and they're notified of it when they're called up, of a deployment in the foreign country, then it would qualify. Does that answer your question?
It does, but it seems unfair. You'd rather go overseas than Quantico.
To meet the definition of qualifying exigency, yes. There must be a deployment in a foreign country. To move on, and it's certainly related to everything we've been discussing, is the military caregiver leave, the 26 weeks of leave that will be available. And unlike the qualified exigency leave that we were just discussing in relation to that last question, to be a covered military service member for this type of leave, deployment in a foreign country is not necessary. It can either be a current service member or a veteran who's undergoing medical treatment on an outpatient basis, or if the current service member or veteran is on the temporary disability retired list. And in the case of care for a veteran, the leave must be taken within 5 years of the veteran's last day of active duty. And I want to reiterate that this isn't just the spouse, parent, or child of the employee. It also includes the next of kin of the covered military service member. We want to also define what a serious injury or illness for a covered military service member is for that enhanced 26 weeks of leave as a military service member caregiver. And as I said earlier, the active duty has to have played a role in the injury or illness. It has to be something that was either incurred during the active duty, or it could be a prior condition that was aggravated due to the active duty. And it must render the service member or veteran unfit to perform the duties of his or her rank or office. There's other ways, however, a veteran's injury or illness could still qualify for that military caregiver leave of 26 weeks, and that's when the USVA service-related disability rating is determined, and it's at least 50% under that rating system. It could be when the veteran's unable to secure employment due to a qualifying injury or illness. It could also be when the veteran or the caregiver is enrolled in the Veterans Affairs Program of Comprehensive Assistance for family caregivers. So after covering a couple different ways that an employee may qualify for FMLA leave, the next thing we want to talk about is some common issues that come up for employers, because we recognize this is a sensitive situation. It's when something serious has affected one of your employee's life, and so sometimes there can be a little bit of a rift between employee and employer, and if you cover some of these issues in advance, it can usually head off any type of dispute. The things that we commonly see when an employee notifies its employer, his or her employer, of the need for leave is there needs to be a designation first and foremost if the employee is going to receive FMLA leave, the request and approval process, that is. Then, a lot of times, it's not just the employee going out for 3 weeks and then coming back to work. A lot of times, the employee is going to need intermittent leave or leave on a reduced schedule. Another issue then, after that, is scheduling the leave. What does the employer have to do? What does the employee have to do so that the leave is scheduled in a manner that does not disrupt the employer's operations? Then the employer will have to calculate the leave, and we're also going to include here a special note about maternity leave policies and some ways that employers run into discrimination issues. So like I said, the first step is determining whether the employee is going to receive FMLA qualifying leave. The employee has some responsibilities, though. He or she has to give 30 days notice to the employer to the extent possible. Obviously, sometimes that's just not going to be possible. If the employee's husband is in a serious car accident one day and needs to care for her husband, she's not going to be able to give the employer 30 days notice. But other times, especially for pregnancy sometimes, unless there's complications, the employee is going to be able to notify his or her employer that he or she is going to be going out after the birth of a new child. The employee also must provide sufficient information for the employer to decide whether the leave qualifies under the FMLA, and the employee has to provide a certification so long as the employer requests one, and that's usually in the form of a doctor's note. And it's important to realize that so long as the employer holds up their end of the responsibilities under the statute, failure to comply with any of these responsibilities of the employee will be usually grounds for denying the leave. Now, on the other hand, the employer, like I said, has some responsibilities. The employer has to inquire with the employee, has to have a communication procedure for soliciting enough information from the employee to see if he or she qualifies for leave. The employer must notify the employee of his or her rights and responsibilities under the FMLA. The Department of Labor has a standard notice form that's easy to obtain. And it's not required, but we strongly recommend that the employer request certification from the employee, especially if it's, and we'll talk about this a little bit later when we go over some common legal claims, but if the employer is a troublesome the employee is a troublesome employee, if he or she has some absenteeism issues, if you have any reason to question whether the need for leave is legitimate, you'd obviously want to request certification from the employee. And then after that's all said and done, and not enough employers really do a good enough job of this, you need to issue a well-written decision of whether the leave was granted or denied, and if denied, state the reasons. That's usually one of the foremost exhibits on behalf of the employer when you have an FMLA-related lawsuit, is that letter stating all the reasons, all the ways that maybe the employee didn't comply with his or her responsibilities under the statute, didn't give enough notice, didn't give enough information, didn't give a doctor's note as requested. State those reasons in your written decision why leave was denied. Yes, we have a question in the audience.
Thank you. You mentioned a doctor's note, but there's also an FMLA certification form. Which one do you recommend that employers use?
Use both. There's no reason not to use both.
Nick, one question on something you passed by a few minutes ago, but from the webinar, it seems to me, the question is, could caregiver leave deplete FMLA leave for an employee's own serious health condition? So if someone has already, say depleted all of their FMLA leave for the year for caregiver leave, and then they have a serious health condition, what happens?
It could. It's 12 weeks in the 12-month look-back period, however that's decided by the employer. And so there's examples in the federal regulations where an employee, if they take 4 weeks to care for the birth of a new child, for example, then they would have 8 weeks remaining of unpaid FMLA leave. This doesn't speak, obviously, to any other types of leave that might be available, but just under the FMLA, they'd have 8 weeks remaining for their own serious health condition. So another common issue for employers is the need sometimes for intermittent leave or leave on a reduced schedule basis. Again, this isn't generally the type of situation where an employee needs to just take 4 weeks of continuous leave because of the birth of a new child or any other qualifying reason. This is where an employee, for example, is recovering from surgery, maybe, and they can no longer work 8 hours a day because of their recovery process. And it'll be divided up into either intermittent leave or reduced schedule leave. And the difference there is that intermittent leave is leave that will be taken in separate blocks of time due to that single qualifying reason. Chemotherapy is a common example where someone will have to be out periodically on various days of the week. Reduced schedule leave, on the other hand, is when an employee's typical work hours will be reduced because of that FMLA qualifying reason for the leave. It oftentimes will involve converting the employee from a full-time employee who might be working 40 hours a week to a part-time employee. So many times the employer will be required to offer that intermittent leave or reduced schedule leave. It's really any of the qualifying reasons for when an employee is eligible under the FMLA except the birth, adoption, or foster care placement of a new child. That said, the employer can still offer intermittent leave or a reduced schedule to the employee for the birth, foster care placement, or adoption of a new child, but it's at the employer's discretion. There's no legal obligation to do so. The next issue in the leave determination process is scheduling the leave. And this is admittedly a sticky situation for a lot of employers because they realize that, well, especially if it's a key employee, that they're going to be, the employee's absence is going to maybe cause a disruption to the employer's business. There's going to need to be a replacement. There's going to need someone to cover that shift. The employee has an obligation to make a reasonable effort not to unduly disrupt the employer's operations. And the employer may require a temporary transfer, which better accommodates the recurring periods of intermittent leave or the reduced schedule. But there's some critical requirements when that transfer happens. The transfer has to be to the same or substantially the same type of position. I mean, it has to have equivalent pay and benefits. It has to usually have equivalent privileges. You can proportionally reduce some of the benefits like accrued vacation, but only if the employer's regular practice is to tie those accrued benefits to the employee's work hours. And after the period of leave, the intermittent leave or the reduced schedule, after the need for that type of leave is gone, then the employee generally has to be reinstated. They do have a right to reinstatement to their old position. There's a little bit of an exception there for what's called key employees that we're going to talk about later, but generally reinstatement is required. And that's a common area where we're seeing a lot of litigation. So the next step then, you've determined that they're leave eligible. You've determined that you're going to give them maybe intermittent leave. You've determined how you're going to schedule it. Now the employer needs to determine how much leave is available to the employee and how much leave is taken after the employee is out. So we mentioned this earlier. The employer has the discretion to choose the 12-month period where the employer will look for the FMLA leave bank. It can be just the calendar year, January to end of December. It could be a fixed 12-month period determined by the employer. Some employers like to tie it to their fiscal year if it's not the same as the calendar year. It could be a 12-month period after the very first day of leave, the need for the leave arises. Or, and this is also very common, it can be what's called a rolling 12-month period, which means you look backwards for the preceding 12 months after the very first day of the need for leave. No matter what the employer chooses, it's imperative that the employer consistently apply their policy. If they're going to change their policy for some reason, here, they have to give 60 days notice to all of the employees. And if they just don't choose a 12-month period, then whatever is most beneficial to the employee is going to apply. They're going to get the maximum amount of leave bank that's available under any of these options. And I have a little asterisk next to the 12-month period here because for military caregivers, the employer doesn't have this option. It's 12 months from the very first day of the need for leave when it arises. So after the employer chooses their 12-month period, the next step is to calculate the amount of leave that's taken. You have to decide in what increments the leave is going to be measured, and then because the statute provides weeks of leave, 12 weeks of leave, you have to determine how much of a week of leave has been taken. Intermittent leave or reduced schedule leave is measured, like I said, in increments, but the increment can't be any greater than either an hour or the smallest increment that the employer measures other type of leave. So some examples here, if an employer measures their paid vacation time in 1-hour increments and for some reason measures paid sick time in half-hour increments, then FMLA leave that's taken is going to be measured in half-hour increments because that's the smallest increment that the employer uses for other types of leave. On the other hand, another example, if the employer provides paid vacation time in half days or even full days, like a lot of employers, and just doesn't provide any paid sick time, well then the FMLA leave has to be measured in 1-hour increments because that's the maximum that's permitted incrementally under the statute. After you determine the basis for measuring the increments, the next step is to determine the portion of a week of leave that's been taken, and that's determined on a pro rata basis that's equivalent to the employee's work week. Again, some other examples. If there's a 40-hour work week and the employee takes 8 hours of intermittent leave during that week, well, that employee then has used a fifth of a week of his or her FMLA leave allotment. In the same example, though, and you can see the difference here where a reduced schedule versus intermittent leave, if the employee has a 40-hour work week typically and he or she works half days because, for example, he or she's recovering from surgery, then that employee has used half of a week of FMLA leave for every week that that occurs. Part-time employees have a different calculation usually, say a 30-hour work week where they take 10 hours of intermittent leave. You can see how the denominator there affects the leave bank allotment and how much leave is taken out of that leave bank. That 30-hour work week employee who takes 10 hours of intermittent leave has then used a third of a week of his or her FMLA leave. And there's a note at the bottom there about using averages for varying work schedules. Sometimes because of the business needs of the employer, an employee's work schedule will vary considerably. And to get that denominator then for the calculation, the employer is permitted to take the average from the preceding 12-month period. And just before I hand it back over to Megan, I said that earlier that I wanted to have a note about maternity leave. And that's because we're seeing a lot more discrimination claims now from fathers. Fathers who claim that an employer's maternity leave policy is discriminatory because mothers, after the birth of a child, we're not talking about pregnancy leave here, we're talking about post-birth, mothers, for some employers, are entitled to more leave than fathers are. And the only reason, unless it's a disability-related issue, if there's a complication, say, with the pregnancy, the only reason for that different leave sometimes between fathers and mothers is gender. And that's a discriminatory basis for the employer's policy. So we advise a lot of clients that if you have a maternity leave policy and a paternity leave policy, just change it. Make it a parental leave policy. Remove the gender issue and have it consistent for both fathers and mothers. I should point out, though, that if they're taking FMLA leave after the birth of a new child, that notice requirement still applies. Leave after the birth of a child is one of the areas where an employee is usually able to give his or her employer that 30 days notice that's required. And there's a note down here about the same employer limitation, and it doesn't happen too often, but sometimes an employer employs both the mother and the father of a new child. Well, the father and mother don't both get to take 12 weeks of leave each because of that new child. It's per child. So if the mother, for example, takes 4 weeks of leave after the child is born, then the father can only take up to 8 weeks of leave to care for that new child. And with that, I'm going to, after giving that overview, I understand it can be a little dense sometimes, I'm going to hand it back to Megan. She's going to dive into some of the more discrete issues about pregnancy, childbirth, and nursing.
Quick question, Nick and Megan, from the webcast. Isn't the decision about granting intermittent leave subject to the doctor's determination, not the employer's determination in terms of, she says, I'm talking in terms of medical leave. So is the decision about granting intermittent leave subject to the doctor's determination is the question.
You'll often see in the certification forms, the doctor will say that leave needs to be given on an intermittent basis. And so in some ways, to answer the question, yes, it is. But it's also important to remember that intermittent leave, except for leave that's taken after the birth of a new child, it's required to be available anyway. So the employer is already under that obligation. Some of the decision-making is already removed from the employer. They don't have that discretion. But you will often see the doctor put in the doctor's note that this employee needs intermittent leave or to work on a reduced schedule for X number of weeks because of his or her serious health condition.
Okay, thanks.
Thanks, Nick. That was great. And now we're going to transition. Oh, you have another question.
I have a question about the same employer limitation. So if the parents were working in different places, they would be able to get the 12 weeks and 12 weeks.
That's correct.
And it's under the FMLA that states that it's only 12 weeks per child with the same employer? It's under the FMLA it states that?
Not in the federal statute, in the federal regulations promulgated by the Department of Labor. There's the same employer limitation, yes.
Okay, thank you.
And Nick, one quick follow-up question from that same questioner regarding intermittent leave. If the employer feels that the intermittent leave requested arrangement won't work, can they refuse it? So say there's a doctor's note requesting intermittent leave, but based on the nature of the job duties and the nature of what's required, the employer says that's just not workable. Are they allowed to refuse that request?
Well, they're entitled to the intermittent leave generally, but that's when and I said it was a sticky situation earlier because that's when some of the transfer issues might arise. One of the options the employer will have is to say, well, this is going to be a big disruption to our operations. We're going to transfer you to another position that will accommodate your need for leave, whether it's on an intermittent basis or otherwise, during your leave period. But that's when litigation sometimes arises because there's a dispute between the employee and the employer where the employee is saying, statutorily, I have a right to this leave. And unless it's for the birth of a new child or adoption or foster care placement, they have a right to intermittent leave. So in some cases, no, the employer doesn't have the option to refuse the intermittent leave, but they will have the option to transfer the employee to a different position that can better accommodate that statutorily protected intermittent leave.
And what's the kind of standard for when that transfer decision can be made? I mean, is it similar, So the same kind of standard under the Americans with Disabilities Act, that you have to make a reasonable accommodation for someone with a disability, but it doesn't mean you have to keep them in their same exact job. Is it the same sort of flexibility that's allowed here, or is it a higher or stricter standard for when you could transfer someone to a new position? Let's say that there's a request for intermittent leave, the doctor's note supports that, but the person's in a really sensitive position where there's going to be a very high-level sensitive negotiation going on for the next 6 weeks or 2 months and whatever, and the need to have the same person in that position, and you cannot have someone coming in and out. It just won't work. Is that a situation where you could justify a transfer, or can you do it really at any time when the employer determines that it's just not workable?
That situation touches squarely, and we're going to talk about it later, the key employee exception to this rule. And the standard there, it's pretty high. It's will the employee's transfer or the reinstatement after the need for leave ends, will that cause substantial disruption or grave economic harm to the employer? And on top of that, not only must the employee be key, but they have to be earning quite a bit of money for the employer. They have to be in the top 10% in terms of salary for all employees within 75 miles of their work site. So there is an option. There is an outlet for employers when an employee is so critical that it's going to cause this substantial disruption to the employer's operations, but it's a fairly high standard to meet for that key employee exception.
So it sounds like it is a higher standard than, say, might apply under the ADA. I mean, it's a bit of apples and oranges, I know. But.
Yeah, apples and oranges to the extent that the ADA, it's an undue hardship standard.
Right.
It's been I haven't seen too many litigations where they're comparing those two different standards, but you can just look at the language used in the statute. It is substantial disruption or grave economic harm. That shows the legislature's intent for a pretty high standard.
Okay, thanks. Megan?
Thank you, Jeff. Thank you, Nick.
One more question here from there.
Just one quick question. It says on here per child. What happens in multiples, twins, triplets? Is it still per birth, or is it?
So we're still talking about both parents work for the same employer?
No. Or yes or no. We have some of those.
It's still 12 weeks. So 12 weeks is the maximum, and obviously you as the employer have the right to provide more leave. You may have different policies, but they're entitled to 12 weeks following that birth, adoption, or placement.
Even if it's twins? If there's 2 kids involved? Same thing?
Right. It's still 12 weeks.
Okay.
Okay, so to kick off our discussion regarding pregnancy, childbirth, and lactation, I'm going to have a bit of a lawyer nerd moment here and quote the Supreme Court. In a really, really fascinating case, the Supreme Court held that women may not be forced to choose between having a child and having a job. I just think it's a great quote. As a lawyer and a woman, and it's a pretty fascinating case, Automobile Workers v. Johnson Controls, where a battery manufacturer actually had a fertility policy where if you're a woman and you can get pregnant, you can't work there. So the policy didn't apply to men. It just applied to women. And basically the employer was substituting their judgment for the judgment of the women, saying, no, this is a fetal protection policy. It's up to us to protect your potential fetus. And the Supreme Court said, no, I mean, the bias here is clear. Fertile men are allowed to make the decision, fertile women are not. This is not okay under Title VII, which we've talked about briefly, prohibits discrimination on the basis of sex. And then, going to the next slide, speaking of Title VII, one of the major things we're going to talk about here with regard to pregnancy discrimination, is the PDA, the Pregnancy Discrimination Act. So in 1978, this act amended Title VII so that the Title VII language, which says you cannot discriminate in the terms of employment because of sex or on the basis of sex, now, following 1978 PDA, sex also includes pregnancy and related medical conditions. So essentially making pregnancy a protected characteristic. Now the basic principle here, I hope is simple and obvious, that you can't discriminate in the terms of conditions of employment on the basis of pregnancy. You can't refuse to hire. You can't fire. You can't refuse to promote. Now, that's the obvious stuff. It does get a little bit more complicated than that. That's what we're going to get into. I'm going to delve into some specific issues regarding benefits, regarding abortion, regarding married or unmarried women. So just some of these highlights here. A woman is protected against practices such as being fired, like I said, refuse a job promotion. And this includes contemplating pregnancy or actually being pregnant. And you'll see here I have a note that says regardless of marital status. So surprisingly, there have been quite a few cases where the employer said, whoa, 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 we didn't fire her because she's pregnant. We fired her because she's pregnant and she's not married. And the courts have come back and said, okay, nice try, but that's not going to work. We are going to protect this pregnant woman regardless of her marital status. I would be remiss if I didn't say there are some very, very limited exceptions. I'm going to tell them to you, and then I want you to forget them. The exception is if it is a bona fide occupational qualification. I can think of one case where this actually worked. Employers try it all the time. I can think of one case where it's actually worked, and this was a girls' home that took in young foster girls and helped teach them morality and all sorts of cultural and social norms, and they actually had a we get married before we have children policy, and one of the social workers got pregnant. She was not married. We fired her. This is literally the only case I can think of where it was upheld. Lots of religious organizations have tried the same thing to no avail. So, I'd be remiss if I didn't mention that, but let's just go ahead and say you're not going to fire your employees because they're pregnant regardless of their marital status, and leave it at that. So, additionally, one of the things that tends to get a little bit more complicated is leave. That word invokes so many issues, but one of the major things is you can't force your pregnant employees to go on leave so long as they can, are willing and able and want to work. So you as the employer, again, cannot substitute your judgment for your pregnant employees and say, we're worried about the baby. Or this is an inconvenience to us. We think you should go out on leave now. Similarly, they go out on leave following the birth of a child and are ready to come back. And you say, that child's so young. We don't know how we feel about that. Not your call to make. She's able to work. She's ready. She's willing. PDA says you need to let her work. Now, big thing here, I have a note. Unlike the ADA, the Americans with Disabilities Act, the PDA does not impose a duty to accommodate pregnant employees. If, however, other employees who take disability leave are entitled to get their jobs back when they are able to work again, so are women who have been unable to work because of pregnancy. And I'm going to go into this further, but that's similar with regard to light duty, alternate positions. As it stands now, it's going to depend on what you're doing for other employees. Are you letting other employees with medical conditions take on light duty? Are you letting them come back to work? Because again, the issue here is equality. You're treating pregnant women equally. Similarly, women cannot be discriminated against in the area of fringe benefits due to pregnancy or related medical conditions. I'm going to delve into this further. Now, one thing that people don't realize, I think it's great, this extends to coverage of men as well. Obviously not the men themselves, but men with pregnant spouses. So you have a policy that covers certain conditions. You can't, and you extend it to spouses. You can't then exclude coverage of pregnancy conditions for your male or female employees' pregnant spouses. Okay? So in that regard, or another example would be discrimination by association. A woman gets pregnant, it's a high-risk pregnancy, your male or female spouse of the pregnant person, your employee, is having to take a lot of time to take care of that high-risk pregnant spouse. There may be, this is all fact-specific, there may be situations where the employee is not performing and you can terminate his or her employment, but you can't do it because he or she has a pregnant spouse. So in that regard, it does extend to men as well. So delving into benefits a little bit more. So like I said before, in the area of fringe benefits, such as disability benefits, sick leave, and health insurance, this same principle applies. So if your pregnant employee, is unable to work for pregnancy-related reasons, she's entitled to the same disability benefits or sick leave on the same basis as employees who are unable to work for other reasons. We cannot exclude pregnant people. Additionally, she must be accorded the same seniority and vacation retention and accrual accorded those on other disability leaves. So, for example, when somebody is out on a medical leave, they do not accrue vacation, then your pregnant employees don't have to accrue vacation either. But if you have somebody out on a medical leave and they do accrue vacation, seniority, et cetera, those same rights need to be afforded to your pregnant employees. And like I said before, any health insurance provided must cover expenses for pregnancy-related conditions on the same basis as expenses for other medical conditions. You cannot exclude it. Now, there's an exception, and that's abortion. And I'm going to talk about that in a little bit because that's a tricky one. Infertility. This is another hot topic, and this is one that has evolved a lot over the past couple of years because infertility by itself is not actually covered by the PDA. Men and women can be infertile, and PDA it's a women's law, folks. Only women can get pregnant as of now, and so but anybody can be infertile. However, most of the procedures that correct infertility are performed on women, and therefore infertility procedures performed on women are protected by the PDA. What does that mean? You want to terminate somebody because they're infertile? I can't tell you that's a per se violation of Title VII. They're fertile or infertile, but it could end up having a disproportionate impact on one sex or the other. So I don't want to tell you you're free and clear. But you want to terminate somebody because they're undergoing in vitro fertilization, then that flies right in the face of Title VII and the PDA. Okay, now I told you abortion's another tricky topic here. And quite frankly, a very touchy subject. And I know a lot of these things are things that as employers you'd rather stay far away from, and it gets confusing because at times we as your lawyers are saying, don't talk to your employees about this, such as whether or not they want to have children. And then later on in the phone call, we're saying, do talk to your employees about this, such as whether they need family and medical leave or whether they plan on breastfeeding. It's confusing. It's a landmine. I don't envy you. I love it. Call us. That's what we're here for. Abortion. Okay. An employer cannot discriminate in its employment practices against a woman who has had or is contemplating an abortion. Now, something to keep in mind with health insurance. I told you there's a health insurance exception to the PDA. Health insurance for typical expenses arising from abortion may be elected by the employer, but is not required except for in two circumstances. One, the life of the mother would be in danger if the fetus were carried to term, then health insurance needs to cover that abortion, or where medical complications have arisen from an abortion. So that is, I have an additional note about that second part. An employer's health insurance plan must cover additional costs due to complications arising from an abortion, such as excessive hemorrhaging. So you're not covering the basic abortion, but any care for the excessive hemorrhaging. Okay, now another question we get a lot, is pregnancy a disability? Whew, that's a tricky question. Under the ADA, the Americans with Disabilities Act, normal pregnancy is not considered a disability, okay? It gets a little tricky, and we're going to talk about this when you get into ADA, the amendments to the Americans with Disabilities Act, which include a lot of temporary disabilities. But baseline is normal pregnancy is not considered a disability under the ADA. However, complications resulting from pregnancy can be impairments for ADA purposes if it affects a major life activity and the major life activity is substantially limited. What am I talking about? For example, gestational diabetes. The Department of Labor has just come out and said that that is covered. That is, even though it's a temporary disability, it is a disability. particularly under ADR. So if circumstances surrounding this unusual pregnancy trigger ADA coverage, an employer may have an affirmative duty to accommodate the disabled employee if the accommodation is reasonable and does not pose an undue hardship on the employer. And it's always very, very fact-specific. And when the issue arises, it does require the employer to engage in what the courts call an interactive process with the employee. It's a discussion. Again, it's talking about the scary things. So generally speaking, with ADA, employment discrimination is prohibited against qualified individuals with disabilities. And an individual has a disability if she has a physical or mental impairment that, like I said, substantially limits one or more major life activities. She has a record of that disability, or she's regarded as such. Now, I wanted to mention these sort of ADA basics because you may have a pregnant employee who's not disabled, but you regard her as disabled, and then if you make a decision that negatively impacts the terms and conditions of her employment, ladies and gentlemen, now you're not only on the hook under the PDA, you're on the hook under the ADA. So if you haven't been following so far, pregnancy is invoking FMLA, PDA, ADA, and as I said in the beginning, state and local laws. And this is one of the big things where I said what I tell you today may be different tomorrow. Not only is the Supreme Court considering hearing a major pregnancy discrimination case that could affect the landscape of all of this, but additionally, states left and right are enacting, such as Maryland very recently, enacting pregnancy discrimination and protection laws, additional human rights laws, additional disability accommodations laws. So it's just something to stay on top of. Okay, now we talked about pregnancy and disability under the ADA. Now, like I said, pregnancy and disability is also relevant under the PDA, the Pregnancy Discrimination Act. Under the PDA, disabilities caused or contributed to by pregnancy, childbirth, or related medical conditions shall be treated the same as disabilities caused or contributed to by other medical conditions for health insurance plans, leave benefits, including the type of leave that you're given, whether it's paid or unpaid, for example, other benefits and employer policies. So this is where I said, if you have a policy where individuals with certain medical conditions are allowed to have light duty or a reduced schedule or an alternate position, then those same considerations must be, or accommodations rather, must be afforded to your pregnant employees. It is a tricky area. It depends on where you're living, what jurisdiction, because like I said, this is a hot topic in the courts right now. Certain courts have held, for example, that if you only provide these alternate positions, light duty, et cetera, to employees who are injured on the job, and that's it, you don't afford them to anybody else, then you do not have to afford them to pregnant employees. But the courts are divided on this topic. Some courts say if you offer it to anybody, it needs to be offered to pregnant employees. And again, particularly now with recent changes to the ADA, a lot of employees who are recommended by their doctors to go on light duty or have an alternate position, chances are there's probably some sort of temporary disability issue, so it requires a multifaceted analysis. Now, I mean, Nick told you everything you need to know about the FMLA, so I should just leave now. But I will talk briefly about pregnancy in the FMLA. As Nick said, a mother can use 12 weeks of FMLA for the birth of a child, prenatal care, and incapacity related to pregnancy. This includes morning sickness. That's considered a part of the health condition reason for taking leave. And for her own serious health condition following the birth of a child. So what does this mean? You have an employee who is chronically 15 minutes late due to morning sickness, or you have somebody who is hourly and is spending, more than the de minimis break, 30 minutes, an hour in the bathroom every morning. That employee may be protected by FMLA. It may mean that you don't need to pay for that time while she's in the bathroom getting sick. But she does have job protection, and it is something that you're going to need to consider if you have an eligible employee. And a father can use FMLA leave for the birth of a child and to care for his spouse who's incapacitated due to pregnancy or childbirth. Now, lactation and nursing. This is another thing that's been changing with a lot of states enacting local laws, and the recent Patient Protection Affordable Care Act, which amended the Fair Labor Standards Act, which is our federal wage law, to require employers to provide nursing mothers with break time, a private place to express milk, and the ability to store milk. So this applies to all employers and employees that are covered by the FLSA's overtime provision, so your non-exempt employees, unless there are fewer than 50 employees, and I don't mean by location, I mean in general, and the employer can demonstrate that these requirements would impose an undue hardship by causing the employer significant difficulty or expense when considered in relation to the size, financial resources, nature, or structure of the employer's business. So I'm going to get into each of those a little bit more. Reasonable break time, okay? I really wish for you guys and for myself that the federal government gave us a little bit more guidance, but they didn't. They did give us some, though, so let's talk about that. So reasonable break time to express milk for 1 year after the nursing child's birth. And this is throughout the day each time she needs to do it. So what's reasonable? Well, I'm jumping ahead. What's reasonable? You need to consider, I have this down at the bottom here, the frequency, number, and length of breaks that a nursing mother might need. And how do you determine what she might need? You need to talk to your employees. You need to find out how old the child is, how often she's breastfeeding. Some people have breastfeeding limitations where they have to express more often but in shorter times. Some people express milk fewer times throughout the day and they are able to pump more. You need to have a conversation with your employees. And you also have to consider related factors. How long is it taking the woman to walk to the lactation space that you've designated? Where are you making her keep her pump? Where are you making her keep her stored milk? So things like this. Now, employers are not required to compensate nursing mothers for breaks taken for the purpose of expressing milk. However, if you are an employer that permits short breaks throughout the day, generally under the Fair Labor Standards Act, these short and reasonable breaks, a duration of about 20 minutes or less, and you compensate for those, and a woman decides to express breast milk during those breaks, you can't then not pay her. So you're still paying. However, if you give these breaks, these ordinary and customary breaks, and then the employee decides to take additional breaks to express those times or to express more, you don't have to pay her for those additional breaks. And important note here, this can't be counted against FMLA entitlement. So the morning sickness can, the prenatal visits can, the birth of the child, the care for the child, not lactation. FMLA and PDA don't really get into lactation. That is why the federal government responded with this break time for nursing mothers law. Okay, so I said you need to provide.
Megan, quick question. Does the space and time for pumping not apply to exempt employees? Do these rules apply equally to exempt and non-exempt employees?
That's a great question. When I said that it's your non-exempt employees, it is literally just your non-exempt employees. You can provide break time and space for your exempt employees, but you are not required to under federal law. However, and again, I know I sound like a broken record, but it's really important, you may be required to under state or local law.
That's perfect. And of course, that always begs the question, do we have our employees properly classified as exempt and non-exempt, an issue that you guys get asked about and work on constantly. We did cover that in one of our monthly programs here maybe a year or a year and a half ago. We've covered actually most of the kind of the hot button employment-related topics, employees versus independent contractors, telecommuting, exempt versus non-exempt, what's compensable time. If you're interested in any of those, we have all of our recordings of our nonprofit legal seminars on our website. The link is on the last page of the PowerPoint presentation today. I'd encourage you to listen to those if you're interested in those topics.
Great, thanks, Jeff. And I should also make a note that the federal government does strongly encourage employers to provide lactation breaks for exempt employees. And to Jeff's point, not only does it get tricky with classification issues, are your employees properly classified, but you can't go about deducting time from your exempt employees' salaries, because you could end up destroying what's called the salary basis test. I hesitate to go down this primrose path. But if you're making improper deductions, your employees might not be exempt anymore. So it's not just that these women who are exempt don't get breaks. They just don't get breaks. They're not protected under this law. The federal government encourages it. You have to be very careful what you're doing with exempt employees' compensations. And if you have a policy that has a disproportionate impact on your women because they're lactating, then you could also be in violation of Title VII. It's never easy, is it? It's never black and white. Okay, so lactation space and storageability. This space cannot be a bathroom. The federal government says that in every way possible. I mean, it's in the law, it's in the regulations. It can't be a bathroom. It has to be shielded from view, free from coworker and public intrusion, a place where you could reasonably express milk. It doesn't need to be permanent. If you don't have the capacity for a permanent lactation space, you only have one employee breastfeeding. It can be temporary. You should consider the number of nursing mothers at any given time. Maybe you need multiple spaces. Maybe we take this conference room and we put up curtains or partitions so that employees can come and use that. The government has said, the DOL has issued guidance that said that would be okay. The mother must have a place to sit and a flat surface other than the floor where she can put her breast pump, and preferably, although not required, strongly encouraged electricity access for the pump. Now, I also said she needs to have the ability to store the milk. That doesn't mean that you need to have a breast milk fridge. You can let a woman keep her breast milk in the common fridge, or you can just make sure she has a space to bring her own cooler. Now, that's a summary on pregnancy and breastfeeding. I know we're running short on time here, but we have just two other sections for you, which will be much shorter. I'm going to pass it back to Nick for common family caregiver legal claims. And yes, ma'am. Absolutely.
Yeah, let's take this one question and then get through the rest of the presentation, and we'll take a few more.
Years ago, we were advised not to call a policy a maternity policy because it was discriminatory against men, and we were advised just to call it a disability policy because our maternity policy said that women out on maternity were out for 6 weeks. Well, they said to drop that and just call it a disability policy. But here it clearly says that pregnancy is not a disability.
Okay, that's a great point. Pregnancy is not considered a disability under the Americans with Disabilities Act. However, pregnancy may and often is a disability under your disability policy, under state laws, so under relevant policies and laws. And if you are providing short-term disability benefits to individuals with other medical conditions, you need to include pregnancy. And that's why you're getting that advice, because as Nick said, when you provide leave for the care of a child, it's not related to medical conditions stemming from pregnancy. For example, the woman's time in the hospital, its recovery, et cetera. It is about care of the child that needs to be provided equally to men and women and should be a parent leave policy. But many employers, you'll find that, and women just call it maternity leave. Oh, I get 3 months of maternity leave. My husband only gets 1 month. Well, that's probably because there's 1 month of parental leave that both the men and the women get, and then 2 months of short-term disability leave. And then that disability leave may vary based on whether you have a vaginal delivery or cesarean section. And again, that's going to be not only about the local law, the state law, but also about your insurance policy, your disability benefits. So now, without further ado, back to Nick Ryder.
Thanks, Megan. And as we're wrapping up, we just want to provide some quick hitting points on common litigation trends that we're seeing in this space, and then Megan's going to talk about some handbook and employment policy tips, basically ways to try to prevent those litigation issues from affecting your organizations. So the first one that I want to talk about is pregnancy. Megan just touched upon it in a number of different ways, but there's probably even a fair number of people in the room with us or listening on the web that have heard or seen things in the workplace whether previous jobs they've had or hopefully not where you are now, but where someone is asking a question that reflects the employer might be making a decision based on a pregnancy or a potential pregnancy. There's countless cases where, and they're few and far between now, but over the decades prior, where employers would ask during an interview, are you planning on becoming pregnant, to a female candidate? Or maybe after the hire has already been made. Well, are you going to just leave us in a couple years and go out on leave after you have a child? That obviously reflects some type of discriminatory animus that's based upon either the pregnancy or the potential pregnancy. There was a recent case where a critical exhibit in support of the plaintiff's case was an email after a female employee announced that she was going out on leave because of a pregnancy, and someone in this higher up in the chain of command sent an email to a number of other male supervisors saying another one bites the dust. Those aren't good emails to have floating around on your server, especially if you're on the wrong end of a pregnancy discrimination litigation. There's a note here, too, about Title VII, which Megan discussed, and it says that unpaid leave policies must not discriminate against mothers. Say the FMLA doesn't apply to your organization, but you still have a leave policy either for disability or for other conditions. Well, you can't then not provide the same type of leave to mothers when they become pregnant. It has to be equally available to pregnant mothers. The next type of litigation that we're seeing quite a bit of, and it's not on everybody's radar right now, but it is prohibited under most federal employment statutes, and that's disability discrimination by association. Say an employee has a disabled child or a disabled spouse or a disabled parent that they care for. The employer might worry that that employee will be less productive or less available maybe, or not able to perform the job functions because of their care for that disabled family member. There was another recent case filed, still pending right now, we don't know how it's going to turn out, where the employer passed over a male employee for a promotion, allegedly because the employer is concerned that that employee is merely going to be distracted by his child with a serious mental disability. So you can see it might not be in the forefront of the employer's mind, but there is prohibited disability discrimination merely by association. Another litigation trend we're seeing, and it's been around for a while, we touched on it earlier, is the transfer or reinstatement issues. There generally is a right for that employee after a transfer occurs, after the need for the leave is eliminated and they don't need to be on leave anymore, they generally have a right to be reinstated to their old position or the substantially the same or equivalent position. Some questions that the employer needs to ask themselves: is the employee still getting paid the same? Is the employee still have the same privileges? Do they still have the same responsibilities that they had before they went out on leave? Are they working at the same location? Sometimes there's litigations because an employee's been moved to a different work site. That might add to that employee's commute. It might be more inconvenient for the employee. And you see here we have the question, is the employee a key employee? We talked about the key employee exception earlier in response to one of the questions from the web. But again, that's if the reinstatement or the transfer would cause a substantial disruption or grave economic harm to the employer, then the employer can take advantage of that exception to the transfer or reinstatement rule. And then last, we often see lawsuits when there's a termination after notice of the need for leave is given by the employee. And sometimes the employer feels a little bit handcuffed. Say you have a troublesome worker with a long history of disciplinary issues. You know, the personnel, we've all seen it, the personnel file is a foot thick. They've been there forever, and you haven't quite let them go yet, but you kind of want to. And then all of a sudden, their husband is in a car accident. They say, I'm going to have to be out under FMLA for a while. And you're suddenly facing a potentially troublesome situation because you can't fire them now. They've just said, I'm going to be out in the future. So they've invoked their FMLA rights. You probably can't fire them right when they come back because then you've retaliated against them for exercising their FMLA rights. So what do you do? Well, you can request certification. We talked about that earlier, especially if the employee has a long history of absenteeism or maybe questionable veracity, let's say, with his or her employer. Make them really show you that there's a need for the leave. You can always discuss with the employee some options, whether it's going to be transfer to a different position or other alternatives. And you probably have to make a real assessment at how strong the personnel file, the disciplinary history is. Because if you can show that there's a legitimate, non-discriminatory, non-retaliatory reason that has nothing to do with this FMLA invocation of rights, that if there's an email somewhere between the president and HR saying, we're going to let this person go, and it predates the date of notice given by the employee, that's going to be critical in backing up your decision-making for terminating this troublesome employee, notwithstanding the fact that they've notified you of the need for leave. And with that, we're going to get to our last section, which is Megan discussing some handy employment policy tips.
Thanks, Nick. Okay, so home stretch. This will be quick. My first bullet point, I can't say it enough, marquee, bright lights, check all relevant state and local laws. Next big one is hiring. Okay, I read Sheryl Sandberg's Lean In, and I loved it, but when she told employers to ask their female employee applicants about their childbearing and rearing possibilities and intentions, I was like, Sheryl, don't. Please don't. Please do not ask your female applicants questions regarding pregnancy, childbearing, or child care. I'd rather you not ask any employees, but you're particularly in the hot seat if you're asking your female applicants that. And do not make decisions based on caregiver responsibilities or pregnancy-related factors. Pregnancy and caregiver leave. I really, really, really strongly encourage all of you all to outline all of your leave policies in advance. This isn't something that I would love for you to be dealing with after you already get the request. It would be great if you know, are you covered by FMLA? Are you covered by a state or local law? If so, put a section about it in the handbook. If you're not covered by FMLA, don't call it FMLA. Don't put an FMLA policy in the handbook because then you subject yourself to these heightened requirements. Have just a family leave, a medical leave, a personal leave, an unpaid leave, but know what you're doing in advance. And that's the same thing for vacation, sick, personal, all of it. And then apply it equally if you're letting somebody take unpaid leave for education purposes, a sabbatical. You need to let your employees take unpaid leave to care for their children as well. And outline your parental leave policies for new fathers and mothers. Like Nick said, if you have a husband and wife team, they may have limited rights. You may have the discretion to extend additional rights. But you're going to want to know what your parental leave policies are, whether or not you have a husband and wife team, or whether it's just you employ the mother or the father. And again, make sure when it's parental leave, it's gender neutral. Anything additional is related to pregnancy. Okay, next up. Pregnancy considerations, again, we're invoking Title VII because of the Pregnancy with Discrimination Act, FMLA, ADA. Know your rights and your employees' rights under each relevant law, and it's always based on the circumstances at hand. All of these things are very fact-specific, usually. Ensure the neutrality of benefits, including fringe benefits for your pregnant employees. Know your return to work policy. If other individuals are out on a short-term disability leave, do you require a fitness certification before returning to work? Do you ensure certain job rights? Whatever you're doing, it applies to your pregnant employees as well. And state laws, like I said, may afford pregnant women or new mothers additional benefits beyond those afforded to other employees, like California, New Jersey, Maryland. Ensure that your nursing mothers have break time and space. Include language in the handbook. Some people want to stay away from this. I think it's a great idea. Put it out there. We use handbooks in litigation as affirmative defenses all the time. Somebody says they discriminated against me, they didn't give me this. We're like, oh, really? Check out page 2 right here. We tell you who to ask. We tell you what to do. And then along those lines, it would be great if you have a complaint procedure. If somebody feels that they've been discriminated against or harassed, and you have an investigation procedure. And you should put that in the handbook too, because again, that can be used as an affirmative defense as well.
And Megan, if I could just plug, please also include the employee acknowledgement form somewhere in that personnel file. Too many times you have a great handbook and then the litigation comes and the employee will claim they never saw the handbook, and it's great to be able to waive as Exhibit 2 to Exhibit 1, which is the handbook. Well, here's your acknowledgement form signed 30 days after you were hired.
Well-written policies are great, and an acknowledgement of those. Thanks, Nick. That's a great point. And then finally, you can put all you want in writing, but if you're not doing good practices, it doesn't get you very far. So please train your supervisors, train your management, harassment training, diversity, sensitivity, discrimination. And with that,
with that, 2 questions from the webinar that were posed a while back, 2 people patiently waiting. One, you just touched on, Megan, in the closing part. If a nonprofit has less than 50 employees, they're not covered by the FMLA, but they offer the functional equivalent of an FMLA policy by written policy. Do we have to comply with all of the requirements, and what risk would there be if we decided to no longer offer it? You basically advise not to make yourself covered by the FMLA if you're not otherwise covered, and then if you do want to offer any particular benefits, make them clear in your policy, but don't call it FMLA, don't reference the FMLA. But maybe that question kind of begs the bigger question of whatever policy you lay out, and obviously it's very important to be very clear, to offer what you want to provide, to not offer what you don't. But what about changing policies? Obviously employers, even the program we're going to be doing in a couple months about bring your own device to work, this is an area where employer policies are changing all the time. What's your basic advice about kind of the fire drill, the steps, the protocol when you want to change a policy, particularly a significant one?
Okay. We get this question a lot, and I invite Nick to join in the response. The biggest thing I always say is please issue a new handbook. It's a great opportunity to get your handbook in front of your employees, even if 99% of it is the same, or you can issue an update and refer them to the handbook. But if you're going to change your policies, you're going to want to make sure that you have a good business justification for doing it. You're going to want to put it in writing, ideally. You're going to want to make sure that it is communicated to all employees. And then you're going to need to be careful because there are situations where somebody may essentially be grandfathered in for the short term to the old one. I know that's very general, but it really does depend on what policies we're talking about here.
That's exactly right, because if someone is in the middle of some benefit that you had offered under your old policy and then you change your policy prospectively, you're likely not going to be able to yank that benefit away from them until the benefit's exhausted.
Absolutely. We want to be giving notice, and ideally your notice period will cover those employees who may be mid-benefit. Again, we're speaking generally. But regardless, notice, communication, distribution, and then being careful to see how that affects people who may be, as you say, mid-benefit.
Two things just to add to that point. One, your handbook should address the potential amendments to the policies therein in the future. You should have a line in your handbook where the employee is informed that it's their responsibility to keep informed of amendments that might happen, and that the employer retains the right to amend the contents of the handbook at any time. And 2, and Megan touched on it, and just to give an example, but some policies in the various statutes that apply have a requirement that X number of days of notice is given before the policy change can take effect. For example, the 12-month look-back period for determining how much FMLA leave is available in an employee's leave bank, that requires that there's 60 days notice before that 12-month look-back period can be changed by the employer's policy.
And I just had a client actually change one of their paid time off policies. They did it. All of the employees have access to email. They did it via email. They put an announcement then with a link to the handbook and a way by which all employees could ask questions regarding the change, and received a read receipt of the email.
Thanks, Megan. One more question. If an employee exhausts his or her 12 weeks of FMLA leave but is still not able to return, what legal issues should we be most concerned about? And obviously that's hard to answer that question in a vacuum without knowing the basis for why that person can't return, because it could trigger other laws such as the ADA. But any generic answer to that, high-level answer to that question?
Well, it would be interesting to see what the employee in that situation would advance as a legal theory for any type of claim against the employer. If they're unable to work and they don't dispute that, there's usually not an issue because they're unable to return to the job. More often, it's the flip side of that. It's the employee is now ready to return to work, and for one reason or the other, the employer doesn't want to reinstate them or doesn't want to reinstate them to the same or substantially the same position.
Right. So you're saying if an employee, from medically, their own medical condition, care of someone else, whatever the case may be, if they're unable and or unwilling to return to work and they've exhausted their FMLA leave, then unless the relevant state law provides for greater leave protection, you're generally speaking not going to be under an obligation to hold that person's job.
Right. If they've exhausted all available leave under any statute, state or federal or local, that's correct.
You'll obviously want to consider whether extending the leave would be a reasonable accommodation under the ADA.
That's a really important point because there have been cases, especially in the Second Circuit up in New York where I practice mostly, where a temporary leave has been determined as a reasonable accommodation under the ADA.
Okay. Well, thank you, everyone, for participating. Megan and Nick, thank you for a terrific presentation. We hope to see you all back here next month. Enjoy the holidays, and we'll see you soon.
Thank you all very much.
Thank you.